Welcome to Making the Case. I'm Yodit Tewolde. Jury selection in the trial of Gregory McMichael, Travis McMichael, and William Bryan began its second week today. Around 1,000 people were summoned as prospective jurors in the case of the men charged with Ahmaud Arbery's murder. To start, attorneys are trying to narrow that pool to 64 potential jurors, and so far, they're not even halfway there. BNC's Dre Clark is in Brunswick, Georgia, a small community where this case has opened up old wounds but has also had an impact on new legislation.
Georgia was among a handful of states that did not have a hate crimes bill on the books. This state in the Deep South has a long history of slavery, lynching, and Jim Crow laws. But Ahmaud Arbery's death provoked historic change here. Almost immediately after video showing Ahmaud Arbery's killing went viral, lawmakers in Georgia pushed for a hate crime law. Arbery was jogging through a predominantly white neighborhood just outside of Brunswick, Georgia in February 2020 when he died. Gregory and Travis McMichael are charged with murder for shooting and killing Arbery. A third man, William Bryan, is also charged. Bryan recorded the killing on his cell phone.
In the minds of people, Ahmaud was the perfect victim, just like Jordan Edwards was the perfect victim. The one that you can't say that they were doing something other than living their life when they fell prey to someone's disregard for their life.
Paul Henderson, a community leader in Brunswick, campaigned, calling and emailing people all across the state to get support for House Bill 426. And last June, Georgia Governor Brian Kemp signed that bill into law. The hate crime law allows judges to increase sentences for people who target their victims based on actual or perceived race, color, religion, national origin, sex, sexual orientation, gender, or mental and physical disability.
The growing diversity in the state of Georgia made us the right place to get this law passed.
Georgia first passed a hate crime law 20 years ago, but the state Supreme Court reversed it, calling the law vague. In 2019, a bill passed the Georgia House, but stalled in the Senate. Ahmaud's tragic death made the difference the third time.
We're part of a national trend towards seeing people for their humanity.
Only 3 other states, Arkansas, South Carolina, and Wyoming, don't have a hate crime law. Atlanta attorney Gerald Griggs is with the NAACP.
It's unfortunate our dear brother Ahmaud had to pass away for legislatures to see the importance of this, but it was the impetus to push it through. So now Georgia has, joined the majority of the states around the country that has hate crime protection and enhancements.
And the law here in Georgia also requires data collection on all hate crimes committed here in the state. In Brunswick, Georgia, I'm Dre Clark for Making the Case.
The judge who initially projected jury selection would go for at least 2 weeks is now frustrated at the slow pace of questioning, which may drag this process for a few more weeks. Here to discuss the latest in this trial, veteran prosecutor and BNC's legal contributor Paul Henderson and criminal defense attorney and past president of the National Trial Lawyers, Mark O'Meara. Great seeing you both. All right, let's get right to it, though. Once again, back and forth between the defense, the prosecution, and the judge was a major headline of the day. Here's what happened. Shortly after lunch, the defense made an oral motion to add questions for potential jurors that address what they called a, quote, unfair system that has been accompanied by movements. The defense specifically mentioned the justice for Ahmaud mantra that they say encourages a guilty verdict. One of the proposed questions was, if you were in the place of the accused, would you want someone with your views and your life experience on the jury? The judge told the defense that the prosecution needed time to prepare a response to the motion before he would make a ruling. Then jury selection resumed. But within a few hours, the defense asked the question to a juror. The state objected. The judge said the question was inappropriate, even saying it could be viewed as racially charged, again warning the defense to wait until a ruling was made. Paul, The majority of the prospective jurors that have been questioned thus far has proven one thing, or three things at least. One, that they know the case too well, that the individuals know the defendants, or are too afraid to serve. All reasons why this process is proving difficult to find a jury in this case. And these additional questions by the defense seem to be aimed at proving just that, yet they haven't asked for a motion to change venue. They think that they could actually find a fair jury pool right there in that county, but these additional questions seem to suggest otherwise.
That is correct. And these questions in particular, I think is really interesting. And I'm so glad you read them out so that we could see exactly what the defense did, because I think it reveals some of their strategy. The courts have ruled in the past that it is an illegal question to ask jurors or potential jurors to put themselves in the place of the scene that they are about to decide the facts on. That's because it's too controversial, and it tries to be an indication of how they would vote before they hear the evidence that gets presented to them. I think that's a real problem and a precursor from the defense to try and taint this jury and get a verdict thrown out ahead of time by asking illegal and inappropriate questions. But the bigger issue, back to your point that you had raised, was what is taking so long to get this jury, given the three factors that you had indicated. I would add a fourth factor that I think is more complicated about this, is unpacking an approach to race in public safety and in violence. And I think navigating that has been a delay for both sides to try and figure out how to approach that topic and how to address it directly, because I don't think there's a way around it in a case like this, and that does make it more complicated. They only went through 71 folks last week, and there are 1,000 people that have been called to answer this subpoena to come in for jury duty. It's not a subpoena, but have been called in for jury duty. And I think they just have to come up with some solution about how they are going to shorten the questions or shorten the selection process to get to the jurors that they need to sit on this case because of those reasons.
Motions challenging something as being unfair are becoming a trend for the defense. Mark, last week they made the claim that black supporters of the Arbery family gathering outside the courthouse could influence members of the jury. The defense said those demonstrations should be banned. The judge reminded the defense that the courthouse grounds are public property, but told them to file a motion if they wanted to. Now, this is sort of a double-edged sword in that I understand to some degree what the defense is trying to argue here, not just in this case, but in a lot of high-profile cases, which I'm sure you understand, Mark, that there's a lot of undue influence on juries, with factors outside of the courtroom. But if it weren't for the media coverage, for the exposure, and of course that video, we wouldn't be covering this trial of these three white men for the murder of Ahmaud Arbery.
If it wasn't for the video, we wouldn't be having a trial. I mean, let's face it. If it was up to the now present defendants to have told the story without a video, it would have been a story much closer to true argued self-defense, that Ahmaud was the aggressor, whatever. So we're only trying this case because we have that video. But I will tell you, as to the jury selection issue, I've always considered jury selection to be sort of a three-dimensional chess. You've got different levels that you're playing on when you're trying to get a juror. So in this case, let's not forget, the defense does not want to leave this area. They want to get their jury from this community because they perceive, and rightly so, I believe, that this jury pool would be biased in favor generally of the defense. That from that community, we know it's Southern Georgia. We know that there is a lot of these racial components that exist, subtle as that may be and active as they may be. So on one level, they want to stay exactly where they are and pick their jury from this community. But also what they're doing is, I think, a very good and subtle job when they throw out these questions. I agree with Paul, although I think they're being more subtle. I don't think it's obviously an illegal question, but I think they are on the edge of trying to show to the jury and also to the panel that they're going to eventually pick up, and also to the community, how to address this and resolve it in a way that's favorable to the defense I think that subtle question, the way they're doing, and the motion that they filed last week to try and stop protests, I think that's speaking more to their jury panel, who, don't forget, are still listening. They're not bound yet by this judge. They're hearing these motions, they're hearing the arguments, but I think it is somewhat of a dog whistle to the community that they're playing to try and get a panel set that's going to be very favorable to the defense.
All right, Paul, Mark, stay with me, because after the break, we'll talk about what we heard from some of the jurors today. We'll be right back. Tonight, we're talking about the arduous process of picking a jury for the trial of the three men charged with murdering Ahmaud Arbery. Back with me, Paul Henderson and Mark O'Meara. All right, let's look at some of the responses from prospective jurors questioned today. Then we'll talk about which side, if any, might be angling them or to get them on the panel. Okay, so there were at least 2 black men questioned today, one of whom was juror number 386. He said plainly, if Ahmaud had been a white man, it wouldn't have happened. He also said he's watched the cell phone video several times and probably liked a run with Ahmaud post on social media, but he said he hasn't gone to any rallies, doesn't feel any pressure from the community, no matter what the verdict is, and despite his own experiences, he can be objective. Paul, shall we be honest here? When you have a community that is 70% white, you've got 3 white defendants and a black victim, the state is looking for any person of color to throw on that jury.
Yes, I would say generally yes, but I would have to have some questions for them first. But given those responses and given the racial background, I would put 2 pluses underneath that juror's name. And that's how I do when I do jury selection. It's a plus, a minus, or a 0 for more questions or answers that I need. But with those responses that indicated, 1, that this was a juror that appeared culturally competent in terms of reflections about race, that's a big plus. The fact that he articulated something that should not have happened or would not have happened, to me, is a reflection of some judgment from that person. That's another reason as a prosecutor that I would want them on the stand. And then the fact that they had said that they were very clear and specific about being able to be fair and objective, but possibly had liked some of the comments that he had seen on social media about Ahmaud Arbery, to me, would tell me that they are following in an algorithm that is sending them messages about Ahmaud Arbery that's supportive of Ahmaud Arbery, and that would be another big plus to me. So I would be arguing vociferously to keep that juror, and those would be good indications for me that I would want them on my jury as a prosecutor in this case.
All right, let's look.